Okay, well, good morning, everyone. I'm Alexis Hall, Acting Program Director for the Division of Examinations Technology Controls Program. Before we begin, I'm required to give the standard disclaimer on behalf of myself and today's event speakers, that the views expressed today are provided in our official capacities, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. I'd like to welcome you to our third and last Compliance Outreach Program on Regulation SP. The Division of Examinations Compliance Outreach Programs are designed to provide a forum to discuss compliance issues in a practical way, share experiences, and learn about effective compliance practices. In prior events, we covered the rule's new provisions as they pertain to transfer agents and large firms, and today we're looking forward to an opportunity to engage with small firms. We've received many questions in advance of today's event, and we've done our best to incorporate the answers to these questions in our prepared remarks. We have also set aside time to answer any outstanding questions that you may have, whether you're live here in person or joining us virtually. If you are joining us virtually, please send any questions you may have to the complianceoutreach@sec.gov, and we'll do our best to answer them. I look forward to today's discussion and to continuing to move forward together to promote compliance. Now, please welcome Keith Cassidy, the Director of the Division of Examinations, to officially kick off the event.
Good morning, and welcome to today's event designed to assist smaller firms to comply with the new amendments to Regulation SP. Whether you are joining us in person or online, we hope you will find today's event beneficial and informative. Today, the team will cover the new Regulation SP compliance obligations, discuss what to expect when interacting with an exam team during an examination, and answer any remaining compliance questions. We will also have a workshop where examination staff will engage in an incident response tabletop discussion, review a sample document request list, and demonstrate a mock examination session. I wanted to thank my colleagues in the Division of Trading and Markets and the Division of Investment Management for graciously contributing their time to these outreach efforts. This event highlights the close collaboration that goes on between and amongst the divisions on a regular basis. Although the staff of our divisions may perform different functions at the Commission, we recognize the importance to your forums that we speak with a unified voice. Today, I hope you will witness firsthand how our divisions work as one, sharing insights, exchanging feedback, and tackling issues. Last May at the annual FINRA conference, I outlined the division's strategy for implementing the enhancements to Regulation SP. In that address, we committed to conducting a series of outreach events to promote readiness and assist firms in their preparations to implement the new amendments. In September, we held the first of these events focused on larger firms. In December, we held a second event designed for transfer agents. And today, we hold our third and final event focused on small firms. Through each of these events, we seek to arm you as business leaders and compliance professionals with the information you need to be successful in meeting your legal obligations. I firmly believe that this type of transparent and candid communication strengthens compliance, protects investors, and ensures fair and orderly markets. Although today's event is focused on compliance with the new amendments to Regulation SP, it is just one aspect of our comprehensive effort to engage with you, our registrant population. Through these efforts, we hope to better understand your concerns, communicate our objectives, and clearly lay out a path to successful compliance. So thank you once again for being here. We hope that this is an opportunity to learn and grow together. And now over to Joe Murphy to introduce our first panel.
All right, great. Well, thank you, Keith, for the introduction. I'd like to welcome everyone to the first panel of today's Regulation SP compliance outreach event for small firms. This first panel will cover a brief history of Regulation SP and discuss the new amendments to Regulation SP that the Commission adopted in 2024. Before we get started, as a reminder, if you'd like to submit a question, please send an email to complianceoutreach@sec.gov. Also, we are recording today's event, and the recording will be available on the SEC website in the next 1 to 2 weeks. Now for brief introductions, I'll be the moderator of the first panel. My name is Joe Murphy. I'm the Senior Regulatory Counsel in the Division of Examinations Technology Controls Program, and I'm joined today by two colleagues from our rulemaking divisions. So please welcome James Wintering, who serves as Special Counsel from the Division of Trading and Markets, and Bradley Good, branch chief from the Division of Investment Management. So thank you both for being here. Jim, I think we'll start with you. Could you please provide a brief history to Regulation SP?
Sure. Thanks, Joe. So Regulation SP is a set of privacy rules adopted pursuant to the Gramm-Leach-Bliley Act and the Fair and Accurate Credit Transactions Act of 2003 that govern the treatment of non-public personal information about customers and consumers of certain financial institutions. The original version of Reg SP, adopted in 2000, requires that brokers, dealers, investment companies, and registered investment advisors adopt written policies and procedures to safeguard customer records and information under the Safeguards Rule, and requires the proper disposal of consumer report information in a manner that protects against unauthorized access to or use of that information under the Disposal Rule, which also applies to registered transfer agents. And finally, it implemented privacy policy notice and opt-out provisions, which Congress subsequently amended in the 2015 FAST Act. It is worth noting that although Regulation SP often is discussed in the context of cybersecurity and digital records, it applies to both physical and digital records and information.
Great. Now, to pivot, could you please provide us with an overview of the 2024 amendments to Regulation SP?
Of course. So the Commission, as you're all aware, adopted the amendments in May of 2024, and they became effective in August of 2024. The compliance dates for the new amendments were December 3rd of last year for large firms, and for smaller entities, which we're here for today, June 3rd of this year. The amendments require brokers, dealers, investment companies, investment advisors registered with the Commission, funding portals, and transfer agents that are registered with either the Commission or another appropriate regulatory agency to adopt written policies and procedures for incident response programs to address unauthorized access to or use of customer information. This includes providing timely notification to individuals affected by an incident involving sensitive customer information with details about the incident and information to help affected individuals respond appropriately. The amendments also expand and align the safeguards and disposal rules to cover both non-public personal information that a covered institution collects about its own customers and non-public personal information that it receives from another financial institution about their customers. It requires covered institutions other than funding portals to make and maintain written records documenting compliance with the requirements of the safeguards and disposal rules. It conforms Regulation SP's annual privacy notice delivery provisions that I mentioned a moment ago to the terms of an exception that was added by the FAST Act, which provide that covered institutions are not required to deliver an annual privacy notice if certain conditions are met. And it also extended both the Safeguards Rule and the Disposal Rule to transfer agents that are registered with the Commission or another appropriate regulatory agency.
Great, thank you, Jim. Now, Brad, Jim just briefly discussed this, but could you go a little more detail about the purpose and overall requirements for the incident response programs?
Yeah, sure. I'd be happy to. So, as Jim said, one of the elements of the 2024 amendments was to add a requirement for incident response programs as part of the safeguards that you have to, as part of your policies and procedures related to the safeguarding rule. And the basic standard here is that firms must adopt written policies and procedures reasonably designed to detect, respond to, and recover from unauthorized use or access to customer information. And at a minimum, these requirements must have basically three main elements. They have to assess the nature and scope of the incident, take steps to contain and control the incident to prevent further problems for customers, and where applicable, provide customer notice to affected individuals. One other thing I may note is, so we use this term customer information. Customer information means any record that contains non-public personal information about a customer financial institution. And the application of that is not only to your own customers, which is a defined term, it's different than, say, client, but also when you have your customer information go to other financial or other entities that, and it's handled on your behalf. And thirdly, when customers of other financial institutions, when you handle or maintain that information yourself.
Great, thanks. Next, could you also discuss the new customer notification requirement?
Yeah, I mean, that's a big part of the new incident response program requirements. So Whereas the overall program applies to customer information, the notification requirement is required where sensitive customer information was or was reasonably likely to have been accessed or used without authorization. And so sensitive customer information is a subset of that overall universe of customer information that either alone or in conjunction with other information could create a reasonably likely risk of substantial harm or inconvenience to a person. And I think we have two examples. One is information that's uniquely identified with an individual such that you could be reasonably used as a means of authentication, so like your social security numbers. Another set of examples is identifying information of the person of account, like a account number or username, in conjunction or in combination or with other information that could be used to gain access, so like your passwords kind of thing.
Okay, and how soon do covered entities need to provide this notice?
So the general requirement is as soon as practicable, but not later than 30 days after becoming aware that the incident happened or is reasonably likely to have occurred.
Okay, and then what are those kind of limited circumstances where a covered firm can avoid sending a notice?
Yeah, so the main one is you can rebut the presumption of notification if the firm determines after a reasonable investigation that sensitive customer information has not been and is reasonably not likely to have been used in a manner that would result in substantial harm or inconvenience. This investigation would have to be done within the 30-day time frame, and you have to affirmatively determine this. If it's inconclusive, you must still provide the notice to the customer. And if you're unable to determine which information was accessed, you must notify all customers with sensitive customer information that resides on the information system that was breached. So overall, the purpose is to avoid costs and anxiety to customers of unnecessary notifications where it's clear that there's no harm, but at the same time, where there is the risk of harm, customers have the information necessary to protect themselves.
Okay, and then are there other exceptions to this 30-day notice window?
Yeah, so notice can be delayed after the commission has received a written request from the Attorney General of the United States that notice poses a substantial risk to national security or public safety.
Okay, and then are there requirements about what the notices must say?
Yeah, so the notice generally has to include key information with details about the incident, the breach data, and how affected individuals can respond to the breach to protect themselves, like how you can obtain a free credit report, that sort of thing.
Okay, and then last question for you, are there anything else you want to mention about incident response programs?
I mean, I think the last thing I would say, I mentioned briefly before, but I think it's important to understand the application. So the notification requirements required not only for your own sensitive customer information, but also that of other financial institutions that's been provided to you. In addition, when you provide your sensitive customer information that from your own customers to other financial institutions or other entities such as a service provider, that obligation continues.
Okay, great, thanks, Brad. Now, Jim, last question, I think, for this panel. Can you discuss the new requirements for the oversight of service providers?
Of course. So the final amendments also require covered institutions as part of their safeguards rule, policies, and procedures to establish, maintain, and enforce written policies and procedures reasonably designed to require the oversight of service providers, including, among other things, to ensure that service providers protect against the unauthorized access to or use of customer information, and provide notification to the covered institution as soon as possible, but no later than 72 hours after becoming aware that a breach in security has occurred, resulting in unauthorized access to a customer information system maintained by the service provider, at which point covered institutions need to initiate their incident response programs, which Brad just discussed. Covered institutions are also empowered under these amendments to enter into a written agreement with the service provider in order to provide customer notifications where necessary. However, regardless of whether an agreement like that exists or not, the covered institution maintains the ultimate responsibility to ensure that this notification occurs.
Great, thanks, Jim. Okay, so this concludes our first panel. I want to thank Jim and Brad for joining us and discussing their insights today. Next, I'll turn things back over to Alexis to introduce our next speaker. Thank you.
So the divisions of investment management, trading and markets, and examinations continue to work closely to promote effective engagement with market participants. So it is my pleasure to introduce our next keynote speaker, Brian Daly, the Director of the Division of Investment Management. Brian brings decades of experience advising investment advisors and fund managers on regulatory and compliance matters with senior leadership roles across global law firms and investment management organizations. His breadth of experience across law, compliance, and operations offers a unique and timely perspective, and we're honored to have him here with us today. Please welcome Brian to the stage.
Good morning. I'm pleased to be joining this event today on behalf of my colleagues in the Division of Investment Management. Regulation SP has one purpose: to protect investors. Now, through Regulation SP, the Commission is trying to assist financial industry participants in both designing and deploying policies and procedures that are intended to protect the investors, and especially the retail investors' data and privacy. At the same time, we understand that these challenges may pose challenges for firms, especially smaller advisory firms. But hopefully, this event today shows that we at the SEC, and especially our colleagues in the Division of Examinations, who are your hosts today, really do care about balancing these benefits and burdens. And we look forward to hearing your concerns and thinking through how best to address them. And as you encounter, and you will, as you encounter problems in complying with this rule, we hope that you will please engage with us. It's a new day at the SEC, as you've heard in other contexts. And we are really committed to continuing today's conversation. And if needed, we in investment management are happy to talk about discussing opportunities to provide helpful guidance. So I'm now going to turn things over to my colleagues in exams who are going to walk through the typical examination life cycle. So gentlemen, take it away.
Thank you, Brian. My name is Matthew Guthier, and I am an Acting Assistant Director in the Technology Controls Program within the Division of Examinations. And I'm excited to moderate our final panel today. We'll feature 3 experienced, knowledgeable SEC Division of Examinations staff. And our discussion will cover the division's approach to Regulation SP, relevant risk alerts, and key considerations for preparing for the Regulation SP compliance date. Additionally, we'll conduct a mock examination where we'll walk through our exam workflow, we'll review some sample request items, and we'll discuss interviews and some common observations. But before we dive in, I'd like to introduce our panelists. First, I'm pleased to introduce Sal Montemorano. Sal is a senior specialized examiner and a leading expert here in cybersecurity at the Commission. With years of experience in information technology and cybersecurity, he brings deep insight into today's discussion. Welcome, Sal. Next, I'm pleased to introduce Michael Good. Michael is an IT specialist examiner in the Technology Controls Program. He has extensive experience at the Commission and a strong background in IT audit. Welcome, Michael. Finally, I'm pleased to introduce Steve Hagenbo. Steve is an attorney advisor in the Technology Controls Program. He brings years of experience from private practice, as well as his time here at the Commission. Welcome, Steve. All right, thanks to each of you for sharing your perspectives today. And we'll get started. So first question. So we've already heard about the areas updated by the amendments to Regulation SP. How will the division approach these areas during exams?
Sure, Matt. I'll jump in and let's work on our technical issues to start. So to that point, the TCP, which is the group up here today, our Technology Controls Program, we focus on technology-based exams. We've done this for probably 10 plus years, if not longer, with some of our ART program prior to that. That being said, it's not going to be a new process for us, and it's going to be similar to any other exam with regards to document requests, understanding roles and responsibilities, understanding who's involved in doing the workflow of the technology controls within the business. So how do we really perform these exams? We're going to, again, understand those roles and responsibilities, and it'll start by us getting a sense of your office environment. Are you a singular small office? Do you have multiple offices that you work in? Is it a hybrid environment where you have folks at home, folks in the office, that type of thing? So we're going to try and understand that office workflow, what your lines of business are, as well as your network footprint. So the network footprint is going to be foundational for us to understand where data might reside. Understanding, again, are you in a cloud environment? Are you hosting all of your systems and servers on-premise? Some sort of hybrid of that as well. So understanding your staff, your office space, your network footprint, and then understanding how your data flows within that say, environment, if you will. How do you ingest data? How do you use that data? And we're talking about client data here. And then how do you, say, decommission that data if you no longer are required to retain the data in your data stores. Once we understand all those aspects, it's going to help us ask the questions of, okay, now how do you protect those components? And I'm not going to go too deep on this first response. We're going to have, as we said, a demo a little bit later where we'll go truly very deep on our incident response discussion. And last component here is monitoring all facets of that data flow. So I did want to touch on, I think we received a couple questions prior to the discussion today regarding how should a small firm handle IT controls in their environment. And I think how are we going to look at it if I'm characterizing that properly. Mm-hmm. So I lean on my legal colleagues for this at times. The term facts and circumstances always comes up, right? So we are going to look at the size of the firm, the business lines of the firm, and how they implement their IT operational and IT security controls. Not every solution is going to be the same. It really depends on your business lines and your business services, where the data resides. Do you have a custodian that holds all the client data, or is client data sitting in your environment? So all of those different aspects are going to change the way we look at your controls and to ensure that we find them reasonable and compliant with the new amendments. So there's no real silver bullet here. It's going to really depend upon how, again, your business line functions. And I did want to pass it back to Matt here for some small single person firms. He might have some other perspectives on it.
Sure, and great points, Sal. And just a few things to add. Okay. So we'll start by saying that we understand in these cases, these are small operations. And so we're keeping that in mind. We are expecting that the policies and procedures are reflecting that they're reflecting your operations. And we take this into account when we're reviewing the policies and procedures. So we are thinking about things like the size and complexity of your firm. We're thinking about the nature of your firm's activities, the types of information that you or maybe even your service providers store or process on behalf of your clients, your customers. So at the end of the day, for a solo advisor or a small firm, a one-person firm, we tailor your policies and procedures and consider these things and take them into account when you do. So just a few things to add there, Sal.
Absolutely.
Great. So on to our next question. So how will the division approach examining registrants' identification of risks?
Sure. So a risk management program, again, this will be tailored to the size of the firm, to the business lines of the firm. But we do expect, or we hope to see a risk matrix or risk management program of some sort that identifies risks across the different lines of business. So depending on the size of the firm, depending on the different services you offer to your clients, the risk matrices may look different depending upon the organization. So when we think about a risk management program, I'll break it up into kind of three aspects. You have the identification of risk, the assessment of risk, and the mitigation of risk. So when we look at risk identification, many times when we go and look at firms, they're going to have identification of financial risk and maybe allocation risk, things of that nature. But we don't always see IT operational or cybersecurity risk, which are critical components if you have critical systems in your environment that you're managing. So we want to see that you've considered the potential risks to your operating systems and to your, say, cybersecurity risk based on your network footprint, as I referenced earlier. Once you've identified those risks, we would look at an assessment of those risks as to what type of rating are you going to provide. Are they 1 through 5, high, low, medium, critical, however you want to rate them. And that would depend upon, obviously, the criticality to the line of business. So if you have a component or a server that has all of your critical assets and it must be up and running to facilitate your business, that'd be a critical asset. There could be a critical risk with regards to cybersecurity on that server. Again, very hypothetical. But once you've identified those risks and rated those risks, we would look into a risk mitigation component where you're going to either implement additional controls on a given risk. You may choose to avoid the risk if you have say you have a public website for your company and you decide, you know what, it's not really providing enough business value to me. I'm going to go ahead and take that website down because it poses too much internet-based risk. I'm not saying public websites are bad. I'm just trying to give an example. But you may decide to remove that website, and this way you're avoiding that risk. Or if you feel that the risk is identified and it's such a low percentage chance of occurring, but it's maybe a very sophisticated type of attack would have to happen, or if the service goes down, it's not going to impact your lines of business, or it's not going to impact your business and your clients directly as long as you get it up in a day or so. That may be an accepted risk, right? So you're not necessarily going to put any additional controls. You've just identified it. You know it could happen, and if it does, it's not going to really hurt your business. So those are kind of the say, iterations or manipulations we'd expect to see. The last component is really documentation, right? Did you document the risks that you've had identified through this process? And is it an iterative process? Are you continuing to work through those risks over time? So you've done this workflow. You have your first set of risk matrix, and then over time, risks change, right? AI has come into play over the past couple of years. That has changed the risk for, I'd say, every organization that is internet-based. There's obviously opportunities with AI, but there's also risks, and that's what you have to think about. So how often is the risk assessment and the business lines reviewing that risk? If you open up a new line of business, are you looking at the risk to that new line of business? So to summarize, though, performing that initial assessment and then having an iterative process. And then for us, obviously, when we come and do the examination, we're going to want to look at documentation to see what risks you've identified, what mitigating steps you've taken, and what's the plan in the future. So hopefully that gives a good summary of it.
Great, Sal. Thank you. Excellent. And so one area that the updates to Regulation SP will impact will be the management and oversight of third-party service providers. What are some considerations covered institutions should know with regards to the division's approach for exams? Michael, can we turn to you for this?
Yeah, absolutely. So thanks, Matt. Yeah, so, I think there are a few things, and in particular with small firms, we often see situations where there's a reliance on managed service providers to assist with IT and security services. So very common thing to see, but we do want you to remember that, basically, while you can leverage those managed service providers, ultimately the responsibility still remains with the registrant. So what you want to do is you want to make sure that you are doing due diligence to understand the risk profile, managed service providers, and then you want to make sure you're also doing ongoing assessments as well to continue to make sure that those service providers can meet the obligations that you've negotiated with them. And in particular, as we talk about the updates to Reg SP, particularly as it relates to incident response, this is a key area where you want to make sure that you're engaging with your managed service provider to ensure that they can meet those obligations you've negotiated. What's their particular responsibilities within incident response? Can they respond within the time frames of the regulation in terms of letting you know if there's a breach? Can they communicate that? And then you want to make sure you're doing this on an ongoing basis. So when you begin the relationship, again, you want to make sure that you're doing your due diligence. And as you continue that relationship, you want to make sure you continue to do your due diligence and continue to check in with your service providers. There are many things they can be doing in terms of attestations. You can also look at establishing written agreements with service providers as well to ensure that they continue to meet the obligations that you've negotiated with them. Because again, the key here is the protection of customer information, and that's a partnership that you've established between yourselves and those managed service providers. So those are some key things that I think you can do to make sure and help as much as possible, again, to make sure that that's a successful relationship and that, again, they partner with you and they're meeting their obligations. And I think above all, again, also remember that they will say many things potentially in terms of their capabilities, but you want to make sure that, again, you have done the work to understand that risk, and then also, again, continue to do those ongoing activities to ensure they continue to meet the mark of what you agreed upon in terms of services that you engage with those managed service providers.
Great insights, Michael. Thank you. Excellent. And to remind firms of their obligations under the federal securities laws and help them improve their systems, their policies and procedures, the division issues risk alerts. And what are some risk alerts that small firms can consider reviewing as they engage in the risk identification process? Steve, can we turn to you?
Yeah, sure, Matt.
Cool.
Thank you. So to begin, I'll just say that all of the risk alerts and observations I'll be discussing are available on sec.gov, so feel free to take a look at those after the meeting. So I think one risk alert to start with is an April 2023 risk alert that highlighted a lot of the observations relevant to topics we've discussed and we will be discussing today regarding the protection of customer records and information at registrants' branch offices. And so while some small firms might not have branch offices, I think this is still quite relevant to a lot of the issues that the firms will be facing. So this risk alert discusses observations on vendor management, so as Michael mentioned, so working with third-party service providers, data classification at the firm, technology risk management, things such as patching, email configurations, and access management, so how folks, either clients or staff, access data at the firm. Exams has also released several risk alerts that highlight various cybersecurity threats and observations on topics such as secure cloud storage, ransomware, credential stuffing, and electronic investment advice. And those risk alerts on our website range from May 2019 to September 2020. Finally, Exams has released 2 observation reports that may be of interest to attendees. In January 2020, Exams released the Cybersecurity and Resiliency Observations Report. And this report highlights practices that firms could consider based on observations from examinations. And those topics in the report include mobile security, mobile devices security, and data loss prevention, so ensuring that data is not leaving the registrant without proper controls. And this report encourages market participants to review their practices, policies, and procedures on cybersecurity and operational resiliency. And finally, there was a November 2021 observations from examinations of advisors that provide electronic investment advice that may also be of interest.
Helpful resources. Yeah, thanks for sharing those, Steve. And another question for you. So in general, what are some practices registrants can consider in preparation for this compliance date?
Sure, Matt. So I think probably the most obvious one is to actually review and understand the amendments to Regulation SP. Obviously, there's an adopting release and there's the rule text, but there's also a small entity compliance guide that the divisions of trading and markets and investment management issued. So firms can consider reviewing that publication as well in seeking to understand the amendments. Firms can consider engaging with stakeholders within the registrant and also at service providers to draw on any expertise in functional areas, compliance, information technology, and legal areas to help develop and refine any policies and procedures that might need to be changed. Firms can consider reviewing their policies and procedures, both at the registrant and at service providers, to update where necessary to ensure compliance with the amendments. Firms can consider testing these processes, any new processes especially, to ensure they are operating effectively and as intended. Firms can consider educating and training officers and staff so all understand any new or changing responsibilities as a result of these amendments. And finally, I'll just mention they can consider ensuring service providers are aware of the regulatory changes and are able to comply with any of the changes based on the firm's expectations of what they have with that relationship with their service providers.
Great. Thanks, Steve. And thanks to everyone here for those great insights. Really helpful perspectives on Reg SP and some compliance considerations. But now we're going to shift gears and put some of this into practice. We're going to walk through a mock exam so you can see how these concepts come to life during an exam. Great, yeah. Excellent. I'll grab it. Oop. Apologies, everyone. Great. Here we go. All right. All right, cool. So we have our presentation up, and I'd like to walk through our agenda. So in this exercise, we'll start with some background on our exam workflow. And then during the mock exam, we'll start our scenario. We'll talk through our team's risk assessment. We're going to look at some document request list items, and we'll talk through interviews. And then we'll wrap up with a discussion about common observations. So here, again, the goal here is to give you a clear picture of what to expect and how to prepare. So yeah, let's dive in. We'll start with the workflow.
Okay. So with the examination workflow, and bear with us, we're going to try and tag team this a little bit. But the first step we're going to take when we've identified a registrant that we need to perform an examination on is a risk assessment. Right? The risk assessment is going to consider public information, information that the SEC has gleaned in the past examinations, what we call tips, complaints, and referrals, information that we may have received. So it's going to consider all those facets, and it will basically help us scope the exam, help us say, okay, here's where we see risks for this registrant. Here's the subject areas we may want to focus on when we actually go and do the review. And Mike.
Absolutely. So, following that risk assessment process, then what we're going to do is we're going to let you know that, hey, an examination is going to begin. As a part of that, you're going to receive an initial document request. Now, what drives that document request is a number of things, but particularly the risk assessment, particular subject area of that exam. The mock exam that we're going to kind of work through today will be around focus on incident response. So we'll kind of give you an example of some of the initial document requests that you would receive. But key thing here is that when you receive that initial document request, you're going to want to put that documentation together that we request, and then we're going to take that and we're going to review that documentation so we can really get an understanding of your environment, your controls you have in place, your people, your process, your technology. Could also include lots of things like org charts, again, because when we come for that interview, which Sal will talk about in further detail, we want to make sure that we're prepared and we understand your environment so we can ask targeted questions to, again, confirm our understanding of what you're doing and where you're going.
Right, and so once we've set up let's just touch on interviews real quick, high level. We will do interviews in person, hopefully, not always. Obviously, in the latest environment with COVID and such, we did quite a few interviews virtually. But as practical and as it makes sense, we'll try and come on site. I think most of us feel that a face-to-face discussion, seeing your office environment helps us get a better understanding of how you're performing your business functions. So that's the goal, but if a virtual interview session is needed, we will accommodate as necessary. That being said, the interview sessions are for clarification, right? We are trying to interpret the documentation you provided. Are you actually implementing what is written in those policies and procedures? And we're going to basically ask questions for clarification, ask questions to show us how things are happening, and then we say testing as well. We may want to test, or we do want to test and validate that you are actually enforcing or actually executing those policies within the organization to make sure that, again, the job's getting done as written. So, there have been times in the past where we've seen policies and procedures that look great. We go on site to validate their policies and procedures. They're not doing it. And that's the concern is that it's not just written for us, it's written and executed in the office. And so, all right, now we'll move on to the observations.
Absolutely. So, and Steve's going to talk later in the presentation about observations in more detail, but one of the key things, so, we've requested the documentation. We've had interviews. There may also be follow-up documentation requests as well following those interviews because, again, we may have talked about things that the documentation didn't necessarily highlight. Or, again, as we talk about other subject areas, we may say, hey, can we also get some documentation to understand not only the process that you talked about, but now what's written with respect to that particular subject. And then we're going to take all of that information, and then we're going to look at that, thinking about, of course, the rule, and understanding that. And so we will then maybe come back with some observations. And these may be particular areas for improvement. And we're going to share those observations with you. And again, we'll talk some more about what they can look like, the types of observations. But again, that's going to be an opportunity for us to share those particular areas with you, and then, also get some feedback from you related to those observations as well.
Excellent. Great. So we'll now transition to the mock exam portion of our presentation. And so again, the goal here really is to give you a clear picture of what to expect and how to prepare. So yeah, we can jump right in.
So hypothetical here, we're just, we'll try and keep this in mind as we go through this scenario. We're assuming assets under management, roughly 250 million. Location, so the office is one physical office space, 7 staff, leverages a managed service provider. So they're leveraging a vendor to perform cybersecurity and IT operational functions. And then the custodian, they have a client custodian. So this way, the custodian's handling all the client information. This is how we're going to hopefully move forward in this example, and please just keep it in mind as we step through. So, start off.
There we go. So, let's talk a little bit more about this risk assessment process. Again, we want to make sure that we do our homework before we come in and do an exam. Again, because we want to really focus on, areas of risk. We want to really make sure we understand your organization. Again, the process is not meant to be adversarial. We look at this process as, first and foremost, yes, confirming compliance with the rules, but it's also about adding value for firms and making sure that you are understanding some risk in areas for improvement. And so with the risk assessment, we'll look at public information. So that could be, anything that's publicly available. We'll look at your website. We really want to understand your operations, how you're structured, any of that we can get. Also, if you've had an exam with us in the past, we may look at those past exams. That may give us insight into maybe previous areas for improvement. And then that also gives us some insight into things we may want to review as a part of the current exam. And then we'll also look at if there are other active examinations. Again, we're a technology controls program. We tend to have more of an information technology and security focus. However, there are, other groups, again, our IIC program, our BD program, and so they may be conducting an active examination, and if so, that may be an opportunity for us to join that, or for us to, again, understand what they're covering in that so that we're not overlapping. We'll also look at regulatory filings. So again, anything that you would have maybe shared, filings with us, other regulatory bodies as well, if that's publicly available, those are things we'll also review. That again give us some insight and some context for what you're doing, your operations, where you're going, and things you may have done in the past. And then, as Sal talked about a little earlier, our tips, complaints, and referral system. Again, that's an opportunity for the public to, again, maybe share something with us, and we will also look at that system as well, again, to help us shape and understand areas of risk so that we do our homework, and again, we're having an efficient and effective examination.
Okay, so we'll jump into our initial document request. First off, typically when we do the initial document request, that's going to be accompany an examination notification. So I know different groups may handle things differently. So sometimes we'll have an initial kickoff conference. Other times you'll just receive an initial notification letter. But either way, you're going to receive an initial document request with some disclaimers, our specific forms that we provide to let you know what the examination workflow is like and what we expect and things of that nature. So with regards to the initial document request, again, one more caveat, please understand we're not expecting you to have a document called Registrant Compliance Manual. If that's how you've labeled it, that's great, but let's start off though. So we'll put out an IDR containing a request for your Registrant Compliance Manual, written policies and procedures addressing administrative, technical, and physical safeguards, protection of customer information. In this case, we talked about the firm having a managed service provider, so we're going to want to see that contract, what is negotiated within that engagement. Org charts, understanding those roles and responsibilities. risk assessments related to technology, cybersecurity, risk controls, threats, and vulnerabilities. So again, that risk matrix I was talking about, we would look for something that would address those risks that were identified across the board. Stepping forward. And as we said, we're going to try and focus on incident response on this scenario. So from an incident response standpoint, we're asking for or requesting documentation for the covering your incident response plan, right? Policies and procedures that document registrant program to detect, respond to, and recover from unauthorized access or use of customer information, including customer notification procedures. So really trying to understand, do you have this documentation in your policies and procedures? Listing of staff, vendors, contractors, or other persons responsible for incident response. And listing of all tools that facilitate detection, monitoring of registrant's network environment. And just to clarify some of that again, anybody who's involved in that incident response process, we'd want to understand their role, their function, what their purpose is. And then any tools that you have that are involved in that incident response process, we're going to, when we make this request, our goal is to understand what tools you're using, but we're also going to go further on those tools to understand the capability, making sure that they have their purpose built to do the work that they need to do to make sure you can discern the proper log data, the proper information to say, yes, customer information was impacted or not in the event of an incident or a breach. But we'll touch on that a little bit more in a moment. Reports or supporting documentation that confirms monitoring of information systems, networks, personnel activity. So again, any artifacts that would show not only do you have these tools in place, but do you have the functioning reports that you can review and make sure that, yep, there are no problems, we're running fine, or that actually shows anomalies or anything that needs to be looked further into. And then if the registrant has suffered a security incident during the review period, provide documentation demonstrating the incident response program steps that were followed. So if you say you have a platform, maybe you use SharePoint to track your incidents, we're going to want to see, okay, what identified the incident, how long until you started to respond to that incident, what steps were taken to respond to the incident, how did you remediate and recover? And again, we'll get into that as we talk about the interview section. So, but that's kind of the initial idea. This is not an all-inclusive. Depending upon the scope of the examination, there may be another dozen exam requests or document requests. But this really focuses, again, on incident response and a high level on the other, on just the governance and the oversight of, or the overview of the company. So this is a subset, just please understand that.
Okay. Yeah, so let's talk a bit about the interview process and what that phase looks like. Again, we're going to come out and we're going to want to talk to a number of people. So usually Chief Compliance Officer is always a part of that conversation, CIO, CTO, managed service providers. Now, many small firms may say, whoa, I don't have all those people. They're not a part of our organization. Here's the key. The people in your organization, we understand they may wear multiple hats. So the folks that are involved with information technology, information security, whatever their particular title in your organization should be present. And again, if you're also leveraging a managed service provider, it will be helpful to have that personnel there because they'll be able to answer questions about, technology, services, because some of our questions will be technical in nature. And so we do want to make sure that we have personnel there that can answer those questions. So when does this meeting occur? It usually occurs at a mutually agreeable time. And then we're going to try to work with you to find a time that works for all. And then where? Now, we're typically going to come on site to your office. And if for some reason that can't happen, then we can conduct the examination interview virtually. But we certainly prefer to come on site. I think it's easier for us to get an understanding of your environment when we're on site, also being able to meet with folks in person. And again, it's not an adversarial thing. It's a thing for us to really confirm our understanding because we've already taken a look at that documentation that you've given us. And now we're coming in because we may want to, drill down a little further on particular areas, again, to confirm our understanding of your people, your processes, and your technology. Now, you'll also see here that we've referenced the NIST cybersecurity framework. And I think it's important that in your organization, whether of course, today we're talking small firms, but, whether we're talking to medium, large, whoever you are, you definitely want to have some kind of security framework to really think about your risk and your controls. Now, today we're talking about the cybersecurity framework because it's something that's freely accessible and I think fairly digestible, certainly within the time that we have with you today. But we are not prescriptive here, so that means that any number of frameworks that you want to leverage, you can use. Whatever makes sense for your environment and your business that helps you, again, assess your risk and implement controls. But we did want to talk about this just because, again, we do see a number of firms that do leverage the cybersecurity framework. And again, I think it also dovetails nicely in some respects with updates to the rule as we will talk about incident response. So just wanted to highlight a few things around this. First is, identify. And so what that means is, okay, let's identify your data, your systems, your technology, your services. And what that's going to do is, again, that helps you really build that full risk picture. And then you move to protect. And so that's where, again, you're looking at the controls that you're going to have in the environment. You usually want to have a mix of detective and preventative controls, hopefully more preventative, but you actually want to definitely have something out there that also will let you know if there are things going on in your environment. And then from there, these are the parts of the cybersecurity framework where we talk about how that sort of partners up with incident response in terms of detect, right? So do we have things in place that will let us know if an incident has occurred? Because again, we always want to go back to protection of customer information. And so whether you've got on-site IT services or you're leveraging a managed service provider, do you have those tools in place to know when something's happening in your environment? And then there's respond. So again, now that we know something's happened, what do we do? How do we respond to that? Again, that's going to be a partnership, particularly for small firms, because many of you may leverage managed service providers in this process. So they may let you know, hey, we're seeing some unusual activity, and that's where that incident response program comes in and your plan, because now it's time to put that in action. And then after that, we've got our recover. And with recover, that's really going to be how do we get back to normal? So lessons learned, looking at what happened. Are there things you can do following that incident, now that you've recovered from it, to respond, and so that in the future you don't have that particular issue? And again, there are a number of frameworks that you can leverage that will get you to the same place. Many of them also map back to the cybersecurity framework, but it's just something that we've noticed a number of small firms use just because of its availability and a number of resources that are attached to it. And when you do that whole thing, that's really what that govern piece, right? So not only are you doing this initially when you're setting up your program, but you want to continually do this as a continual improvement, and then also recognizing that risk may change. You may add new processes, you may add new business lines, and so what are the risks that are incurred as you're doing that? And then you want to make sure that the controls that you have in place are responsive to those risks.
Right. Now, thank you, Michael. So I'm gonna try and step through a few scenarios where you may leverage this incident response process, and other scenarios where we're going to be asking some questions that would reflect the environment I mentioned earlier. So when we talked about the environment earlier, small single office, managed service provider, one of the questions we may ask is, hey, and I think I alluded to this earlier in one of the earlier questions, though, is how do you ingest, utilize, and decommission customer data, right? As we're talking to the companies, to the registrants on site, maybe when they ingest data, they're bringing client data in via email. Well, okay, for us, that helps us say email platform is something we need to look into. We need to understand the controls that are applicable to that email platform. So if you're using Office 365, do you have data loss protection in place? Do you have other controls in place that are built into the solution and available based on the services that you've purchased? So we'll look into email because of that solution. I mentioned that you have a custodian managing client data. Okay, how does the custodian receive the client data? Do the clients register with the custodian directly? Do they register with the small firm who then facilitates that communication with the registrant, with the custodian? So we need to understand that data workflow, and that will again tell us what components of your environment may be at risk of hosting client data or facilitating client data, and it helps us target how we're going to look at the controls that you have in place. Do you have those cybersecurity controls in place to monitor the tools that are facilitating that client data. If you leverage a customer relationship management platform, maybe up in the cloud, we'll want to understand, again, what controls do you have in place in that platform? How do you monitor it? How do you monitor access control? And I'm throwing out a lot of different controls. There's so many facets of cybersecurity that need to be monitored, and many of the managed service providers have the capability, have the functions in place to do so. But we're going to want to make sure that they are in place, and those are the components that we'll be testing. So again, understanding that data workflow, if you will, and there's also touching on data mapping. There's in many cases we'll ask for a data mapping matrix if you have it, or how do you know where your data resides within your organization? Do you know how it flows through your organization? So those are some of the components. Other aspects we'll ask about, okay, we've asked for your contract for the service provider. What oversight do you have of that service provider? Ideally, you'll have clauses in the contract that give you visibility or give you authority to request status updates, or maybe you have a weekly, monthly, annual, biannual meeting with the service provider to make sure that not only are they providing the explicit services that you've negotiated, but that they haven't made any changes or outsourced any of their services that they're providing you. In many cases, you'll hire a vendor to do some work. Well, they've outsourced a component of that work and you don't know about that. So that's what we call fourth party risk. That's always a concern. So maintaining that relationship with the vendor is always critical. And we'll be asking about that. We'll also look for reports or some sort of updates that you may receive on a regular basis that would validate you do have that visibility into the vendor's capabilities and vendor's services they're providing. I did have a side note here. Right, how do you interact with your custodians? That'd be another thing. I think I touched on that. Another question would be, walk us through your incident response program to include roles, tracking, and response. And so as Mike stepped through the cybersecurity framework, again, we're going to want to understand where do you track that, how do you track it, what artifacts do you capture, and in this case, with regards to the amendment, are you capturing the artifacts that would explicitly facilitate your determination that nope, client data was not impacted, or that yes, client data was impacted, and then you have to take either take the actions required by the rule. Unfortunately, in the past, we've run into circumstances where incidents have occurred, and the response from the registrant is, well, we don't have any documentation suggesting that the data was exfiltrated from our environment. Well, the lack of documentation is not because they had information that validated nothing went out. They didn't have any log data. There was no retention of logs to say during that time period no nefarious activity occurred. Rather, they didn't have the log data. And so a negative, unfortunately, you can't prove a negative when you don't have the data to validate one way or the other. So that's something we're hoping to alleviate, where folks will have the tools in place and have the log data in place that they can actually make a educated, informed decision as to client data was impacted or was not. And then last question I'll touch on is how do you manage your patch management, vulnerability management, and endpoint protection? And in this case, if we talk about this small firm, they've outsourced their services. So we're going to have, as Michael mentioned, we're going to want to talk to the vendor to understand what capabilities, what tools do they have in place. Now, we don't have to talk to the vendor if the registrant staff have the information. We're not, I don't believe we would force the vendor to come on the phone with us. That's not where we're going. Really, we're just looking for the information to validate what tools are in place, what capabilities are in place, and what tools are enabled. One of the things that a lot of small firms aren't always aware of, if they're not technically inclined, if they haven't been in the cybersecurity or IT operational fields, is that when you purchase a product, and I'll give an example of, I'm trying to be product agnostic, but say you purchase a data loss prevention solution for your email platform. It's great you've purchased a solution, but you have to buy the modules. So you can buy a platform that's going to secure your email, but if you don't buy the modules that would do data loss prevention, do email malicious code review, things of that nature, if you don't buy and enable those modules, then you may not have the solution you believe you've purchased. And so having someone who understands the products, understands the technology solutions that can protect your environment is critical. And Again, not trying to be prescriptive here. It's always helpful to have a third-party objective person who is knowledgeable if you don't have on-staff technology staff. Having a third-party, say, non-vendor, that can actually validate what your vendor is doing is also helpful. So I know I've talked in a little bit of a circle there, but hopefully that's helpful to understand what we're doing when we do these reviews and have these interviews, and trying to validate and confirm that you are implementing the controls that we would expect and that the controls are effective and you have the data you need to make the determination if client data was impacted in the event of a breach. With that, we'll move on to observations.
Oh, sure. Thanks, Sal. So at the end of this, at any examination process, if there are findings, then the commission will issue what's called a deficiency letter. And so that includes one of two buckets. The first is deficiencies, which are violations or apparent violations of a law, rule, or regulation. The second bucket is weaknesses, which aren't actual violations or apparent violations, but are weaknesses in controls that could lead to a violation of a law, rule, or regulation in the future. So a firm will receive this letter from the staff who conducted the examination. And then we've put up here 3 common observations you might expect to see, especially in the SP space. And I'll just start first with saying that Regulation SP's wording requires every covered institution to develop, implement, and maintain written policies and procedures for safeguarding customer information. So that really helps sort of frame how we're going to go through these observations. And I'll start probably with the third bullet here, which is the policies and procedures do not appear to exist. If firms, since firms are required to develop them, they actually need to exist. And so if examiners, ask for these policies and procedures and the firm does not appear to have them, then it's probably pretty likely that we will consider including a finding in a letter that they don't appear to exist. So if they do exist, moving up to the first bullet here, it's possible that the policies and procedures do not appear to be reasonably designed. So Regulation SP requires that the written policies and procedures be reasonably designed to ensure the security and confidentiality of customer information, to protect against any anticipated threats or hazards to the security or integrity of that information, and to protect against unauthorized access to or use of customer information that could result in substantial harm or inconvenience to any customer. So if examiners come in and are reviewing the text of these written policies and procedures, and they determine that they don't appear to be reasonably designed to achieve these 3 goals, or one of these 3 goals, then they would consider including this finding in the deficiency letter. This is obviously a very fact and circumstances specific analysis, and so it's impossible to go into all the permutations of how that might actually play out here, but it's something to keep in mind and that we often consider including in this Reg SP space. And finally, moving to the second bullet here, that policies and procedures do not appear to be enforced. As I mentioned, the covered institution must implement these written policies and procedures. And so we often come into firms, and as Sal mentioned earlier, they have really well-developed and reasonably designed policies and procedures that are written and adopted, but they're just not enforced. And so if the examiners are coming in and seeing that these policies are not actually being implemented at the firm, then we would consider including a finding that the firm doesn't appear to be enforcing these policies. So that's really the three buckets of common observations you'd see in the Reg SP space.
And I want to make a quick comment here is before we issue the deficiency letters, what it would be called, we are going to have an exit conference with the registrant. So what we will do is we'll step through the observations that we've cited or that we've identified through the examination process. And we do give an opportunity for the registrant to say, oh no, we misunderstood, here's the document that covers that area. So we do give a we have a discussion. It's usually about a half an hour discussion, and we'll give a day or two for the registrant to clarify anything that we may have misunderstood. So the goal is not to get a gotcha. We're not just trying to say, hey, we found something. The goal is really to say, yes, there is an issue here. All parties agree, and I won't say all parties always agree, but that we have an understanding based on the data we have. We've made an interpretation based on the information provided. But if there is a specific conflict or a specific component that is not clear and we didn't have all of the data that would have helped us understand the circumstance, then we do give that opportunity before issuing the final deficiency letter. So I just wanted to make that clear. That's a part of that whole observation workflow is we'll have that exit conference. It shouldn't be any surprises. Everything should have been discussed throughout the interview process and the post-interview process before you receive the final letter. So hopefully that helps a little bit.
Great. And with that concludes our mock exam presentation. I'd like to thank each of you for sharing your perspectives today. And thanks to all of you for listening and tuning in today. So we'll take a brief pause, and we'll bring all our panelists back on stage for our Q&A portion. So thank you, and stand by. I think so. Yeah, I think so. Yeah, I think it was fine.
Well, thanks to all of our panelists for a very engaging discussion. We're now going to open the floor for questions, and we're happy to take questions from folks in the room and then also from folks online. If you are watching virtually and you have any questions, feel free to email us at complianceoutreach@sec.gov. And for the folks here, please make your way to the microphone if you have any questions. In the meantime, I'm going to pose two questions we received in advance. Received a lot of questions about these two topics, so let's start with the 72-hour provision. We received a number of questions asking for elaboration on whether certain entities or persons are service providers under the rule. And as to the scope of the 72-hour notice requirement, could you elaborate on those a bit?
Sure, thanks, Alexis. So the service provider provisions apply in full to any person that fits the definition under the rule. So that includes any person or entity that receives, maintains, processes, or otherwise is permitted access to customer information through its provision of services directly to a covered institution. So there are no exclusions built into the rule for certain types of entities. Anyone who fits that definition is treated as a service provider under the rule. Relatedly, as we mentioned in the release, institutions should be cognizant of the fact that an entity can be operating simultaneously as both a covered institution in one context and then a service provider in another one. Firms should thus be mindful of the need to comply with all aspects of Regulation SP that are applicable to their business operations. Additionally, we wanted to provide a little deeper context on exactly what the 72-hour notification provision pertains to. As I mentioned earlier, under the rule, a covered institution's incident response program needs to include policies and procedures reasonably designed to ensure that service providers protect against unauthorized access to or use of customer information and provide notification to the covered institution as soon as possible, but no later than 72 hours after becoming aware of a breach resulting in unauthorized access to a customer information system maintained by the service provider. This differs from the covered institution's customer notification requirement, where affected individuals must be notified unless it can be determined that their sensitive customer information has not been and is not reasonably likely to be used in a manner that would result in substantial harm or inconvenience. So this notification to be made by the service provider pertains to a wider net of incidents and requires less investigation on the service provider's part. For example, if a service provider is aware that one of its servers containing customer information has been accessed, it does not need to first determine precisely what files were accessed. Instead, notification of that covered institution is required. The service provider is not tasked with determining in 72 hours whether unauthorized access or use of the sensitive customer information has taken place. Instead, the service provider's notification of the covered institution triggers the covered institution's incident response program, which includes the obligation that the covered institution make the determination or determine whether customer notification is subsequently necessary. Thanks.
Thank you. The next question, we got a lot of questions about the rules applicability to private funds and their advisors. For example, does Reg SP apply to the underlying limited partners of a private fund? The adopting release states that private funds are exempt, but it's unclear if that also includes private fund limited partners. Are exempt reporting advisors or private fund advisors subject to any parts of Reg SP? What is the impact of the amendments to investment advisors that only have institutional clients? The rules application to private fund investors could be characterized as ambiguous as they are not customers. Could you clarify the rules applicability to natural person investors in private funds? And lastly, can you provide any guidance about how advisors to private funds should think about whether they have responsibilities under these amendments?
Yeah, I'd be happy to talk about that. So I guess when I think about how this would work, right? So as folks pointed out, the way Graham-Leach-Bliley generally works, right, is that different regulatory agencies have different responsibilities for different entities. The Commission has responsibility, among other things, for registered investment advisors and investment companies, i.e., so private funds that do not meet the definition of an investment company, which is most private funds, are not directly responsible or subject to Regulation SP. But the RIA would be, even if they are a private fund advisor. And so I guess the way I think about this is, as we talked about in our remarks earlier, is that there's a different, appreciating that folks use different terminology different ways. In this rule, there's this concept of what a customer is and is not, and what this rule covers as far as whose information it applies to. So for a RIA that has a private fund that's its client, and then in turn that private fund, which is a financial institution for purposes of our rules because it's subject to FTC regulations under Graham-Leach-Bliley, if they collect customer information at the private fund, and then the private fund provides that customer information to the RIA, because of the way Reg SP works, they now possess customer information from of a financial institution, even though it's not necessarily their customers. So I guess I would think about, is that information customer information using the definitions as they apply in this particular SP circumstance, and whether you've come into any particularized information that would constitute customer information for purposes of the rules.
Thank you. It looks like we have a question in the audience.
You hear me?
Yes.
I'm thinking about the example firm that you mentioned, and when examiners come in, how are you approaching the amount of technology that firms are spending? There's limited income, increasing expenses that firms are facing, and really you talk with any technology firm, they love to sell you everything, but there's only so much we can spend. How are you addressing that with firms?
Right. Right. It's a difficult issue, right? Finances is everything, and coming up with the right solution is always a tough balance. Short answer is facts and circumstances, right? We're going to try and understand those lines of business. We're going to try and understand where and how the client data is residing within the organization, within that business. So theoretically, a small business, in this case, we talked about the client custodian. Theoretically, the clients would register directly with the custodian. The business itself doesn't handle any client data, somewhat alleviates any risk to the client data. Excuse me. But we'd have to see that clearly in their technical configurations, that they do not have access to client data, that they're only kind of facilitating the business functions and maybe verbal discussion with the clients, but no real system interaction with the client. So as long as there's no records, no data sets on that environment, that might alleviate many of the controls we're talking about. Might. It all really depends, again, on how everything's working. So that's just one scenario. The point is that it really depends on how they use that client data and where it resides. And so that's how we have to look at it. So I think it really depends. Hopefully that's helpful, but.
Any other questions from the audience before I turn to some questions we received during our event? Okay. Well, thank you for your question. That was helpful. So we received a question: is a firm's technology configuration taken into account when making an overall risk assessment?
Sure. Absolutely. So with regards to the technical configuration, I've seen firms that have basically outsourced their solutions to a vendor. The vendor hosts what we call virtual machines, and the firm was a 3-person firm, I believe in this case, had 0 data on their laptops. So similar to what you're talking about today. But they had 3 folks working off laptops which would access a virtual portal, had access to all the tools in this portal. No data came down to their environment. And so we were comfortable that the data was retained in this portal. Now, that being said, with our new amendments, they definitely have to work on their vendor agreement to make sure that there is going to be the notification in the event that their vendor, who's hosting this virtual environment, has any issues. But point is that in that case, it really helped us get a sense of comfort that even though the folks running their 3 laptops, it was personal laptops, they really didn't have many controls on it. But the vendor they were using had this virtual environment. It implemented security controls, MFA solutions, monitoring solutions, logging, all of the different technical controls we would expect, and they were able to run their business through that process. So I think that's a reasonably good example for this question, and it really helped us get a comfort on their solutions. So.
Thank you. We also received a question about maintaining risk matrices. Can you provide any insight regarding risk matrices that could be helpful to small firms?
I guess that's back to me. So say it one more time. I apologize, Alexis.
Sure. It says, can you provide any insight regarding risk matrices that could be helpful to small firms?
Sure. Let's step back and say there's a number of frameworks out there that help you develop your risk matrix. Looking at frameworks, that would give you an idea of what, say, the scope of a risk framework would be. What do you want to consider? So looking at some frameworks would be helpful. I don't want to be prescriptive on it, but looking at frameworks, and if you type in risk frameworks in Google, you'll find a lot of different frameworks that are applicable. They'll give you a scope of, hey, what lines of business or what risks should I consider across all lines of business? And you'll have to make that determination if it's applicable to your environment, obviously based on your lines of business and your services that you offer. And obviously your network footprint, your office space, there's all a number of risks. So if we talk about risks at a high level, we're talking about, geographic risks, right? Are you in a earthquake zone? Are you in a hurricane zone or a tornado zone? So physical risks as well as the technological risks. Are you a high-value target, depending upon what services you do? Do you have a lot of internet visibility? Are you a small firm that does not have a lot of internet visibility? And so those risks are going to be weighed and balanced, and these frameworks will facilitate that process. So again, not a perfect answer, but hopefully that helps guide folks.
And Sal, if I could just kind of piggyback on that. If you go back to the presentation with the mock exam, we just talked about the cybersecurity framework. Again, not being prescriptive, like Sal said, you got to make the decision about what framework makes sense for your organization based on your risk. But I would offer that with the cybersecurity framework, there's actually a toolkit there for small businesses that does kind of walk you through some approaches that you could take to identifying risk and figuring out what controls you may want to implement in your environment. And again, that framework also maps to other frameworks. So if you make a decision and say, hey, that's not right for me, but I'm looking for a starting place, that may be something you can consider as you start this journey, again, to understand your risk, implement controls to try to mitigate those risks.
And I think that's actually a good segue to the next question that came in. It said during the mock exam session, you mentioned industry standards, you mentioned the cybersecurity framework. Is there an actual requirement to adhere to industry standards?
Right, no, and that's why we say hope and recommend or think about. No, there's no standard requirement. There are a number of standards out there. We did reference NIST. There's the ISO standard. There's COBIT. And then depending upon the technology, there's OWASP for certain technologies. So any number of standards that are available and that can help facilitate compliance, can help facilitate implementing these types of controls. But it is not prescriptive. It's just something that would help, I think, build the program.
Thank you. And lastly, we had a few I see somebody from the audience.
Yeah, I just had a question around the notice of 72 hours from third-party service providers to the investment advisor. Is it reasonable, in factoring in, the certifications, updating the contract or agreement, or having a certification or notice, given the compliance date in June of this year, and many firms may have dozens of, service providers that are in scope, is it reasonable that they reach out to initiate that contract update, but in some cases have a certification, other cases have a notice, and then working towards that, that contract update in the future?
Anyone want to take that?
Sure. So starting off from the beginning here, just some context. As you're aware, the 72-hour notice requirement that we were talking about, the incident response program needs to include the policies and procedures reasonably designed to ensure that you're protecting against that unauthorized access and obtaining that there's a provision of notification to the covered institution as soon as possible, but no later than 72 hours after becoming aware of the breach that you're referencing here. Now, as to your specific question, we would have to be able to, we would recommend kind of coming in and talking for further details about the facts and circumstances, because it's kind of a little more difficult to answer on the fly as to exactly what would be appropriate in those circumstances. And we would definitely encourage you or anybody else who have similar questions along those lines to come in and speak with us, both from the perspective of being able to help you in achieving compliance individually, and then more from the entire industry, hearing back any concerns that you guys have, any things that you're seeing that would be good for us to know that may, depending on how that plays out, inform our guidance going forward to the industry writ large. But we really appreciate what you're coming at here. So I would remind you to kind of look back at that first, but then if you have any further questions, by all means, come and reach out to us, and we'd set up a meeting.
Thank you. Any other questions from the audience? All right. Well, I will turn to the couple of housekeeping questions we received, and one was, what resources for registrants are available on the SEC's website?
Well, I'll reference what Steve discussed earlier. There are the risk alerts. I think those are always helpful documentation that's on the website. There's also a number of videos. If you look into, say, historical events for the SEC, all of these events will be published there over time. I don't know if it's a week from now or whatnot, but we do have some. We did the large firm discussion as well as the transfer agent discussion, and those are posted regarding this topic. But you'll find a number of, I'd say, historical events that might be helpful as well. So,
I may just add too, so when we do rulemaking, there's a lot of documentation we put up on the website from in the regulation section of the website. So you'll see not just the adopting release, which is, I don't know, a few hundred pages probably. So that's only so useful in practice. But maybe most important to this group, we always do a small entity compliance guide that tries to lay out like the basics of what's required in sort of a plain language sort of way. So hopefully folks find that useful as at least a resource to start with any questions you may have too.
Well, thank you. And everyone, you already answered the second housekeeping question, and that is the event recorded and made available online? And Sal just confirmed that, yes, it is. So I just want to thank our panelists again for an insightful and engaging discussion. And with that said, it is my pleasure to now introduce our final keynote speaker, Emily Westerberg Russell, Chief Counsel of the Division of Trading and Markets. Emily has spent more than a decade in the Division of Trading and Markets Office of Chief Counsel, where she works across a wide range of regulatory matters and has been a trusted legal and policy advisor to the Commission. Widely respected for her leadership, judgment, and dedication to the SEC's mission, Emily brings deep expertise and strong commitment to protecting investors and maintaining fair, orderly, and efficient markets. We're honored to have her here with us today. Please welcome Emily to the stage.
Thank you, Alexis, for that introduction. I appreciate I am the only thing standing between you and your lunch hours, so I promise to keep my remarks brief. I want to start by thanking the Division of Examinations for leading this compliance outreach program on Regulation SP, as well as my colleagues from the Divisions of Trading and Markets and Investment Management who participated on the panels throughout the series. I also want to thank the audience who joined us today and those of you who also participated on the 2 earlier panel events, as well as worked with us throughout the rulemaking process. Your engagement with Commission staff is a critical aspect of establishing an effective regulatory regime. This program has been extremely valuable in promoting compliance with a set of rule amendments designed to enhance and modernize important investor protections. That being said, I want to echo Brian's remarks from earlier today and emphasize that the dialogue does not end here. We look forward to continued collaboration with our exams colleagues as they observe how firms are implementing and coming into compliance with the amendments. We also welcome continued engagement from the industry regarding its experience with implementation. These conversations are key to assessing whether additional guidance may be needed. Speaking of the importance of dialogue, before we break, I want to note that everyone in attendance today will be sent a survey or can scan the QR code to provide feedback on today's event. We welcome your input and any suggestions for future compliance outreach events. Thank you all for coming again, and stay warm. I think it's warmer today. Bye.